I am Professor Michelle Harner. I'm a professor here at Maryland. I teach in the business law space. As my students can attest to, I am passionate about everything business law, and I like the enthusiasm. And particularly how we as individuals act through and interact with business entities. The concept of the business entity and this notion of corporate personhood or affording corporations an artificial legal persona is not new. Many scholars actually trace it back to our early churches and having the church being used as a form through which individuals could assemble and act as something greater than themselves. So it's actually somewhat fitting that our last panel discussion for the symposium focuses on the religious exemptions for corporations and this concept of corporate personhood. I'm honored to be moderating this panel because it truly is a fantastic array of knowledge, talent, and expertise. The way we're going to run it is we're going to go in a little different order than what's in the program, and I will introduce very briefly, because I could not do their bios justice even if I took the whole hour and a half. So very briefly, I'm going to introduce each of our panelists, let them give their presentation, and then I'll introduce the next panelist, let him or her give their presentation, and we'll hold questions until the end. Okay? So first up, we have Professor Caroline Corbin. Professor Corbin is a professor of law at the University of Miami School of Law. She teaches U.S. constitutional law, U.S. constitutional law 2, First Amendment, the religious clauses, everything con law. She's con law like I am business. Her scholarship focuses on the First Amendment speech and religion clauses, particularly their intersection with equality issues. She is widely published, and I had just an opportunity to read a small snippet of her scholarship in preparing for today. It's truly fantastic. So even though we're coming upon exams, students, I urge you to pull a couple of her pieces and read them. And with that, I will turn it over.
Great. Thank you. Well, first, I want to thank everyone who made it possible for me to be here today. I really very much appreciate it, and I've been having a magnificent day. So the title of my paper is Corporate Religious Liberty, although the subtitle should probably be Why Hobby Lobby is a Terrible Decision, Part 1, right? So Hobby Lobby, of course, was the decision that held that for-profit corporations like Hobby Lobby were entitled to exemptions from things like the contraception mandate. So my thesis today is fairly straightforward. The question I have set out to answer is, should for-profit corporations have the right to religious exemptions? And my answer is no. For-profit corporations should not have the right to religious liberty exemptions. And to be clear, I'm focusing on the claims of corporations as opposed to the claims of corporate owners as individuals. Their claims should also fail, but for different reasons. All right. So whether for-profit corporations are protected by a constitutional provision, like the Free Exercise Clause, depends not on whether the corporation is a person, but what the clause is meant to protect. After all, despite extending personhood to corporations, the Supreme Court has not found that all constitutional clauses apply to corporations. So the real question is, why do we protect religious liberty? And given those reasons, does it make sense to extend religious liberty to for-profit corporations? As it turns out, the reasons individuals and churches are granted religious liberty rights do not extend to for-profit corporations. So, starting with the religious rights of individuals, why do we protect individual religious conscience? So religiously inclined people might argue we protect religious liberty so that people can fulfill their obligations to God. Right? Failure to do so can cause great suffering now and in the hereafter. Corporations, of course, are not sentient and cannot suffer. They have no soul and certainly no relationship with God. A more secular justification might focus on honoring individual autonomy and dignity, sort of touchstone of constitutional rights. And this justification is grounded in the idea that all human beings possess an inherent dignity, and that respecting people's decisions about their spirituality is very much about respecting that inviolable dignity of the person. But while people are an end in themselves and possess inherent dignity, corporations do not. Right? They are merely a means to an end. They are legal fictions created to facilitate economic growth. These instrumental entities do not possess any inherent dignity we must respect. In short, the reasons we protect individual religious conscience just do not apply to corporations. Corporations are not people, and they are not like people. They lack the fundamental human attributes, whether it be a relationship with God or inviolable dignity, that justify individual religious liberty rights. But what about religious institutions? Corporate religious liberty proponents argue that since religious liberty protections extend to nonprofit corporations like churches, then for-profit corporations should likewise be protected, as they are the same in all important respects. They are both institutions through which people exercise their religion. Actually, it's only well established that churches are protected by free exercise, and the justifications and appropriate scope of free exercise protection for churches is hotly contested, with some arguing that any protection for churches is derived from their members. But even assuming that there should be protection for churches as churches, the reasons we protect churches do not apply to for-profit corporations. So one argument for protecting churches is that they're sacred, the house of God. For-profit arts and crafts stores and other corporations obviously are not. Another is that the churches are crucial to religious freedom because they're the source of theological truth. Right? For-profit arts and crafts stores, not so much. In addition, the practice and promulgation of religion is the overriding purpose of churches. Again, that's obviously not true for for-profit corporations. By definition, for-profits exist to make money. Otherwise, they would be nonprofit. Finally, free exercise protection for churches assumes that the church is an association of voluntary members. This assumption, that the church is a group of people who have voluntarily joined together to pursue religious goals, is highlighted in the one free exercise case where the Supreme Court granted a religious exemption to an entity rather than to individuals. In this case, which created or upheld the ministerial exemption, gives churches immunity from discrimination suits brought by their ministers. In justifying this particular exemption, the Supreme Court emphasized the voluntary nature of the ministers' association. Right? It's permissible to exclude ministers from the protection of anti-discrimination laws because they have voluntarily consented to the church's rather than the court's adjudication of their employment disputes. For-profit corporations, however, are not voluntary associations the way that churches are. Employees are simply not members of corporations the way they might be a member of their church. People join voluntary associations because they agree with the principles of the association. People take jobs because they have to. Now, you could argue that while employment itself may be an economic necessity, employment at these particular corporations is not. And this claim that people can find a job to match their religious views is neither empirically supported nor is it likely to be. Again, the reasons churches are afforded free exercise protection, that they're sacred, the source of theological truth, their overriding goals and acts are religious, and that they're voluntary associations, these reasons do not translate to for-profit corporations. Finally, I just want to mention that Citizens United does not change the landscape. right? It doesn't follow that since for-profit corporations have free speech rights under the First Amendment, that they should have free exercise rights under the First Amendment. And I think Felix Wu sort of explained this. Citizens United, or Bilotti really, protects free speech not for the sake of speakers, but for the sake of audiences. In other words, corporate speech was not protected in order to vindicate corporations' right to speak, but to ensure audiences' right to information, whatever the source. And this audience-focused free speech justification for protecting corporate speech has no counterpart in free exercise jurisprudence. Recognizing corporate religious liberty not only has no principled basis, but it privileges already powerful corporations over their employees. In particular, it opens the door for corporations to seek exemptions from laws that are meant to protect their employees. We saw it in Hobby Lobby. We are no doubt going to see it again. For example, corporations who want to deny health benefits to same-sex couples. Right? This is just going to be the beginning. To sum up, it does not make sense to grant corporations religious liberty. And corporate religious liberty will exacerbate the inequality between powerful employers and their employees. Thank you.
Thank you very much. So next we're going to go to Professor Nelson Tebbe. Professor Tebbe is a professor of law at Brooklyn Law School and a visiting professor of law at Cornell Law School. He teaches courses on constitutional law, religious freedom, freedom of speech, legal theory, and professional responsibility. And his scholarship focuses on constitutional law, and in particular, the relationship between religious traditions and democratic governments, both in the United States and abroad. He, as Professor Corbin, has written extensively on these areas and is widely published, has a book under contract, and I look forward to his comments.
Thanks very much. So it's not news that tensions between religious freedom and laws designed to protect the public good have intensified recently. In Hobby Lobby, for example, the justices exempted a business corporation from the obligation to provide free contraception coverage to its employees, in particular women's contraception. And in the Utah Compromise of last week, a new law extended anti-discrimination protection to LGBT citizens in employment and housing, but completely exempted religiously affiliated employers and landlords. In both of these situations, enhanced religious freedom for employers, among others, came at the cost of equality protections. This conflict has many complex facets, but here I want to focus in on just one of its thornier puzzles. One of the most important constitutional principles for mediating between religious freedom and equality law is the rule that the government should not be able to accommodate private religious citizens when that means shifting meaningful costs onto other identifiable private citizens. Both the Free Exercise Clause and the Establishment Clause embody that rule against shifting burdens to third parties. To continue with the two examples I just mentioned, this principle prohibits the government from accommodating Hobby Lobby's religious practices if that means shifting the burden of paying for contraception coverage to its employees. And Utah may not exempt large employers like Brigham Young University or Deseret News from its employment protections if that means exposing employees to harmful discrimination. Some defenders of Hobby Lobby have responded with a powerful baseline argument, and it's this baseline argument that I want to address today. They say that many denials of government aid or protection do not count as burdens at all. For example, they argue that Hobby Lobby's employees did not have a right to contraception coverage in the first place, and therefore that denying them that coverage as a consequence of accommodating the company's religious beliefs did not count as a burden. Here, I want to address the problem of determining when a religion accommodation can be said to harm someone else. How should we identify the baseline for measuring whether a religion accommodation has shifted a burden to third parties. I'm basing these remarks on a draft paper that I'm working on with Micah Schwartzman and Rich Schrager at the University of Virginia. So I'm going to proceed in just two parts, assuming that I have time. I definitely will do part one, and maybe I'll do part two. So first I want to show why this puzzle is genuinely hard and critically important. And then I want to offer a realist resolution that's robust enough to address the most difficult cases, but simple enough to be administrable. That's part one. And then in part two, I want to apply that analysis to the Hobby Lobby case itself, and especially to footnote 37 of that opinion, where the court offered some kind of unclear and I think unconvincing analysis of the baseline problem. So first, let me describe the problem and offer the approach that I'm recommending. As background, it's important to understand the constitutional principle that's at play, this rule against shifting harm to third parties. We can talk about that if you want, and there's debate about it, but for this talk, I just want to assume that it exists. When the law accommodates religious actors, any resulting costs are ordinarily borne by the government. But if the government instead places those costs on the shoulders of other private citizens, it implicates the religious freedom of those third parties. So a long-standing constitutional rule, as I've said, holds that the government may not accommodate religious actors if that means shifting meaningful burdens to identifiable third parties. Grounded both in the Free Exercise Clause and in the Establishment Clause, this principle guards against government imposition of the beliefs of some citizens on other citizens. That principle was actually reaffirmed in Hobby Lobby. So Justice Alito, writing for the majority, recognized it's certainly true that in applying RFRA, the Religious Freedom Restoration Act, courts must take adequate account of the burdens a requested accommodation may impose on non-beneficiaries. And Justice Kennedy reiterated that principle in his concurrence, which was necessary to form the 5-vote majority in that case. The court cited previous case law grounding this principle mainly in the Establishment Clause, but also in the Free Exercise Clause. Although some scholars have responded by denying that this principle exists altogether in the doctrine, I think that response is totally unconvincing. I think the law is badly lopsided, in fact, in favor of this principle. A more powerful objection has been this baseline argument that I mentioned. So, for example, advocates for Hobby Lobby argue that the Religious Freedom Restoration Act is a federal statute and it predates the ACA, the Affordable Care Act, or Obamacare, which provided the legal basis for the requirement that Hobby Lobby provide contraception coverage without cost sharing to its employees. Because both laws are merely statutes, the argument went, the employees never had a right to contraception coverage in the first place, and when they were denied that coverage, or if they were denied it because of the exemption for Hobby Lobby, that didn't count as a burden on those employees. This is a classic baseline argument, and it can be applied to many types of burden shifting scenarios, such as the Utah situation and others. So it's important to address it. Our argument is that it would be a mistake to simply assume that the absence of government regulation or funding is the natural baseline for measuring all burdens that result from religion accommodations. Formalism like that masks the fact that there's no neutral or natural baseline for measuring third-party harms. Rather, baselines can only be fixed by considering the substantive commitments at play in a particular dispute. Taking for granted a libertarian baseline that imagines no government involvement in the first place would be a mistake. But so would assuming that a baseline is always set by government intervention in a particular situation. Only by carefully examining the values pulling in both directions can we determine the appropriate measure of third-party harms in a manner that's realistic and attractive. In Hobby Lobby itself, for example, women employees and the female dependents of male employees have been harmed by losing contraception coverage without cost sharing. After consultation with medical experts, the administration made a deliberate determination that insurance coverage for all FDA-approved methods of female contraception was a necessary part of the coverage for preventative care that Congress required all employers to carry. That decision established public policy on a core question concerning women's health. Moreover, it did so in a way that protected women's equality. Justice Kennedy is therefore right to say in his concurrence that employees' interest in adequate and equal preventative care was, quote, an interest the law deems to be compelling. Moreover, and related, the Establishment Clause values also point toward a conclusion that employees were harmed. they will reasonably feel that protecting the company's religious freedom has come at the cost of the loss of their health insurance coverage that public officials have deemed to be mandatory, not optional. They will conclude that the court has made a value judgment that deprioritizes their right not to have the beliefs of other citizens imposed on them. Of course, there are important public policy values on the other side as well, principally the value of religious freedom for the company. But on balance, the values at stake point toward a baseline of equal access, not a libertarian baseline of government non-intervention. I don't think every government program will set the relevant baseline for determining burdens on religious freedom, however. Some people who have sought to defend the principle against burden shifting to third parties have argued that in order to fix the baseline in such cases, we just have to look at the status quo of the government programs. And I think that can sometimes be a mistake. Think, for example, of government decisions to deny funding to religious actors. So that's a different area of religious freedom. It's not an Establishment Clause area, but a free exercise one. But the question there is whether religious freedom has been burdened and how to determine whether burden exists. A classic problem is whether those sorts of funding denials count as burdens or whether they should be merely decisions not to subsidize the exercise of a constitutional right, something that the court has said is sometimes okay. Consider the case Locke against Davey. There, the state of Washington had set up a college scholarship program that was available to all students who met certain merit-based and residency criteria. But the program specifically excluded students who were majoring in theology from a faith perspective. Joshua Davey was in the top 10% of his class in a high school in Washington state, and so he was eligible for the scholarship initially, but when he declared a theology major because he intended to pursue ordination, he lost eligibility, and he sued the state. Washington defended the exclusion by citing non-establishment values, such as those rooted in its unusually strong Establishment Clause. And the Supreme Court upheld the program, noting that the financial burden on religious students was not severe and that the religious practices that the state sought to exclude were intensely sectarian. That decision was warranted in our view. The court was right to reject a government funding baseline for reasons connected to two deep constitutional values. First, Washington's decision to deny funding to students majoring in the study of religion from a faith perspective was supported by non-establishment values. Even if the federal Establishment Clause would not have prohibited the funding, Washington had reasons for concern that its tax dollars went to support core religious practices, as the court pointed out. And second, the free exercise burden on Joshua Davey was relatively slight, since the Washington Scholarship Program represented only a small portion of the overall expense of his college education. And the program was only available to a small portion of students who graduated near the top of their high school class in the state. So for both of these reasons, constitutional values suggested that the court fixed the baseline for measuring the burden on Joshua Davey's religious freedom in the right place. Now, you might disagree with what I've said about a particular case like Locke against Davey, bless you. But regardless, the main point here is that the decision can be made neither by assuming a naturalized state of libertarian non-intervention by the government, nor by assuming that government programs always set the proper point of reference for measuring burdens. Instead of either of these, baselines should be set by referring to the substantive public commitments, including constitutional values implicated in a particular situation. That's the lesson I think that's learned by the realists during the progressive era, and that's the most nuanced and powerful approach today. I do have a couple of minutes, so let me say a few words about the court's footnote 37 as a way of applying this to that case. The approach that I've suggested, this realist approach, undermines the court's treatment of baselines in footnote 37 of the Hobby Lobby opinion. There, the court said in dicta that religion accommodations can't possibly be invalid whenever they impose burdens on third parties. After all, deprivation of any government benefit can be characterized as a burden, according to the court. That would mean that religion accommodations could be easily defeated simply by recharacterizing the loss of benefit for a third party as a burden. Here's a quote from the footnote. Nothing in the text of RFRA or its basic purposes supports giving the government an entirely free hand to impose burdens on religious exercise so long as those burdens confer a benefit on other individuals. Otherwise, that's the end of the quote. Otherwise, the court said, government could mandate that all supermarkets sell alcohol, and Muslim owners of supermarkets would have to comply. They couldn't get a religious freedom exemption. Or it could require all restaurants to stay open on Saturdays, and Jewish owners would have to comply or be excluded from the restaurant business. By framing, this is a quote again from the footnote, by framing any government regulation, it was a long footnote. any government regulation as benefiting a third party, the government could turn all regulations into entitlements which nobody could object to on religious grounds, rendering RFRA meaningless. The court then pulled back from the brink, though, and said, we're not questioning whether the third-party harm doctrine exists, because in any event, there was not such a burden on employees in Hobby Lobby itself, something I think that turned out to be false, but that was the way the court reasoned. So is this dicta right? No, it's not right. Start by realizing that it can't be the case that a libertarian baseline should be applied in all cases so that third-party harm can never be found. That's just inconsistent with the case law. Think about United States against Lee, where the court denied a free exercise exemption to an Amish employer who raised a religious objection to paying Social Security taxes. The court said that any exemption would harm the employees and denied the exemption. But that would not have been a concern if the employees could have been said to have had no right to Social Security in the first place. In Hobby Lobby, the court just kind of avoided Lee by saying that that was a free exercise case and Hobby Lobby is a RFRA case. And whether it was right to kind of drive a wedge between RFRA and the free exercise clause as it existed before RFRA was passed, I think is another very difficult question in the case. Moreover, even the court's own examples are inopposite. Once you adopt a realist method for setting baselines, you see that neither public policy nor constitutional values suggest a baseline of government regulation in those cases. A law requiring supermarkets to sell alcohol would serve at most a public policy of convenience for shoppers. That value would be easily overbalanced by a claim of Muslim store owners for religious freedom exemption. Similarly, a law requiring restaurants to stay open on Saturdays would serve a weak public policy, maybe giving restaurant workers more hours, as the court suggested, but it would hamper a strong religious freedom imperative. I think not only are both these examples totally unrealistic, but they also would elicit a baseline of government non-intervention based on the substantive values at stake in those situations. Therefore, third parties would not be seen to have suffered a burden in either scenario. So my conclusion is that baseline arguments that seek to defeat application of the principle against burden shifting to third parties cannot succeed in cases like Hobby Lobby or in situations like the so-called Utah Compromise. A naturalized libertarian baseline of government non-intervention is unattractive and cannot account for the existing case law. But neither is it convincing to always adopt a baseline of government intervention. Rather, constitutional interpreters should adopt a realist approach that sets the baseline for measuring burdens on religious freedom according to substantive values, constitutional and public policy based included, and that pertain in each situation. Thanks very much.
Thank you. That was terrific. And the first two commentators that we've heard, I think, will now set up nicely Professor Taub's discussion, because she's going to take us in a slightly different direction, but still keep us linked to Hobby Lobby and the issues that have been raised so far. Professor Taub is a professor at the Vermont Law School. She and I actually had the good fortune to meet years and years ago at Oxford at a conference, and I have admired her work ever since. She has written extensively in the areas of corporate governance, financial market reform, and mutual fund regulation, drawing on her prior experience as Associate General Counsel with Fidelity. She has a recent book that was published on the financial crisis called Other People's Houses: How Decades of Bailouts, Captive Regulators, and Toxic Bankers Make Home Mortgages a Thrilling Business. And so if you're interested in the crisis and its ramifications on individuals, it's a great read. And I look forward to Professor Taub's comments.
Thanks so much, Michelle. I've admired your work since then, too. And thanks everyone for organizing this event. It's quite an honor to be here, and particularly on this panel. I am not a constitutional law scholar or a religious law scholar. I'm really focusing on the intersection of corporate law and constitutional rights. And so, as you're probably aware, many critics lament that with Hobby Lobby, the Supreme Court further expanded corporate personhood powers. But today, I am planning to offer an alternative reading. I will suggest that Hobby Lobby might actually provide a tool for limiting previously recognized corporate constitutional rights. By that, I mean a tool for a future court majority to use. Now, this may seem naive, overly optimistic, or contrarian, given that, as you know, the case was condemned or celebrated as an expansion of corporate power and recognition of broad corporate purpose. It was also, as you know, decided under RFRA, which is a statute. It was not decided under the Free Exercise Clause on constitutional grounds. And if anything, many might think that this case is inviting in a constitutionally based religious conscience claims for corporations or for profit enterprises, and it's not seemingly a door closer. However, I believe that by designating so far just closely held corporations to be persons with free exercise rights under RFRA, that the court's inviting us to question whether other corporations that lack similar attributes as the three family-run businesses here would be denied such personhood. And if so, could we use this distinction between these closely held businesses, these corporations, and others to curtail corporate constitutional rights? This is not a mere thought experiment, right? As we know, the court held that the contraceptive mandate as applied to these three businesses violated RFRA, and so now HHS has been obligated to fashion an exemption for them in similar organizations, and this is taking the form of a proposed rulemaking. And in this proposed rulemaking, HHS is in fact having to draw some kind of line. What I'm going to refer to today as a Hobby Lobby tool, to carve out those enterprises that are eligible for the exemption. And in the proposed rulemaking, they start out by saying, first, public companies are not eligible. And secondly, they say with regard to privately held firms, they have two different alternatives. One might limit the types of privately held firms that could be eligible to a limited number of shareholders, or maybe by the concentration of ownership. And they also invited the public to comment on how the exemption should be gained. More on that comment process later. What's difficult is that the court didn't provide much guidance. As corporate law scholars, everyone who read this decision reacts to it so differently. For corporate law scholars, we said, wait a minute, what's a closely held corporation, right? The court does not define what they mean in the decision, and there is no uniform state or federal law defining what is now a critical category. Also, what's tricky is my even saying or suggesting they limited it to closely held corporations isn't exactly right. The court is pretty clear in discriminating between classes of corporate entities, and there's some discussion I'll talk about later where they suggest that it could be possible a publicly held firm could get an exemption. Nevertheless, despite the fact that there's not much guidance, I believe there is some, and I think that the court's threshold determination that the corporations were persons under RFRA depended upon the existence of three conditions. The first of these conditions was that the court had to look through each corporate entity, and in the case of Hobby Lobby through a trust that held the stock, they had to look through these shells to see human owners that they saw as coextensive with the corporation. And it was only by doing so that they could conclude that these closely held family-owned businesses were these corporations were persons under RFRA that held sincere religious beliefs. And so this move, looking through the entity, ignores the separateness that state corporate law recognizes between a corporation and its owners. Many of you who've studied corporate law with Professor Harner will know this is an essential doctrine, including when you think about the notion of limited personal liability for owners of the corporation, for the obligations of the corporation, unless there is a veil-piercing exercise, as one example. So what is the evidence that I believe this threshold question of personhood depended on this condition? One example, Alito says, as we will show, Congress provided protection for people like the Hans and the Greens, those are real humans, by employing a familiar legal fiction. It included corporations within RFRA's definition of persons. That's an example of looking through to the owners to find the people. This is going back to Professor Wu said about certain constitutional rights being derivative. In this case, I believe the derivative of the owner's rights. The second two conditions, there's more evidence. This is possibly my favorite passage from the whole decision. It's stunning as a former English major, or just maybe anyone who can read can observe in this how odd the last sentence is. It's odd, but it's actually telling about the court's corporate constitutional rights jurisprudence. Okay, here's what it says. For example, extending Fourth Amendment protection to corporations protects the privacy interests of employees and others associated with the company. Again, looking around to anchor these corporate rights in real people. Next, protecting corporations from government seizure of their property without just compensation. It protects all those who have a stake in the corporation's financial well-being. And here's the sentence I love. And protecting the free exercise rights of corporations like Hobby Lobby, Conestoga Wood, and Mardell protects the religious liberty of the humans who own and control those companies. Wow, what's missing? Where are the employees? You know, what, this is, so to me, regardless of whether I think this is, you want to say where they are? But regardless of whether I agree with this, I'm trying to use this as evidence to suggest, again, that this first condition was so important to the holding. The court chose to look through to the owners in this instance. Didn't have to, but did. Okay, what are conditions 2 and 3 upon which the personhood under RFRA rests? Only because these human owners held or agreed to share the same sincere religious beliefs, 2 and 3, that they actually ran their corporations. This is arguable, but according to the court, they ran the corporations according to those beliefs. Did the court majority conclude that such beliefs could be attributed to the corporate entity? So we look through the corporation, we see these humans, they're very sincere in their religious beliefs. They actually, you know, run this company. They've agreed to run the company that way, and they run the company in accordance with those beliefs. Could those beliefs be attributed back to the entity? Some of the evidence is in this is an interesting part of the decision. It comes up where Alito is dismissing the concerns that what's going to happen next. Are large publicly traded firms going to suddenly come in and have sincere religious beliefs as well that will allow them to gain all manner of exemptions from laws of general applicability under RFRA? And part of what the dismissal is as follows. The idea that unrelated shareholders, including institutional investors with their own set of stakeholders, would agree to run a corporation under the same religious beliefs seems improbable. So again, looking for pieces of evidence that I think these are the 3 conditions. Okay, so where does that bring me? I'm always so hopeful. It brings me to this question. Could these 3 preconditions defining corporate statutory free exercise rights apply in a constitutional rights context? Well, we don't have a free exercise case under the First Amendment, so where would I might look? And so I thought, why don't I look to a Supreme Court decision where the corporate constitutional rights were recognized based upon looking through the entity to the owners? We saw that list. We didn't see any there. But if we did have such a case, might we then ask whether corporate personal rights would also be limited to entities with identifiable human owners that share or agree to share the same perspectives related to the exercise of that right? So not surprisingly, where do I look? Citizens United. Having studied this case closely and written about it before, I think in addition to these questions about listeners' rights, what's so compelling from a corporate law perspective about Citizens United is it also depended upon look-through treatment. What in that case, what Justice Kennedy says is that in the majority that he looks through, I'm sorry, it wasn't Kennedy, it was Roberts who wrote the majority, right? Why did I say it? So Roberts' majority in that case, wait. It was Kennedy. I was right the first instance. I'm sorry. In Roberts' majority, he does look through, and the argument in Citizens is that individual owners, individual humans under BICRA on the McCain-Feingold law would be permitted to spend unlimited amounts of their own money on political advertisements. So they shouldn't forfeit those rights simply because they join together as citizens to form a corporation. So again, that a corporation was seen as an aggregation of human owners. So that was a look-through case. Okay, and then I also looked, there's other evidence in the majority opinion itself as well as in the concurrence, but there was something interesting in Scalia's comments during re-argument. You know, the case was argued twice. And this was one of these telling comments. Most corporations are indistinguishable from the individual who owns them, the local hairdresser, the auto dealer, who has just lost his dealership, who wants to oppose whatever congressman he thinks was responsible for this happening. Then this is the key thing. There is no distinction between the individual interest and the corporate interest, and that is true for the vast majority of corporations. So again, we're seeing a particular conceptualization of the firm for at least this purpose, that corporate speech rights derive to some degree from these owners who are indistinguishable. One thing to also add then, before I turn this back and say how I would create a Hobby Lobby tool to revisit Citizens United, is one of the other compelling parts of the opinion is this part where we hear that there might be a concern, right? If you're looking through a corporation and saying these corporate speech rights are anchored in these human owners, there's a possibility that given the way corporations actually operate, those human owners might not have a say in how their money or how their speech is being exercised. And what the court says to respond to that is, it doesn't exactly call it compelled speech, but there's that piece, that there's further little evidence of abuse that cannot be corrected by shareholders through the procedures of corporate democracy. For those of you who know what these procedures are, they're certainly procedures, but they don't have a lot of substance or give a lot of power to shareholders. But at any rate, one of those procedures, I believe, of corporate democracy that is available after Citizens can be seen in Part 4 of the decision. This is the part that where 8 of the 9 justices sign on and say that it's perfectly appropriate to have further disclaimer and disclosure of corporate political spending. So we have this idea that the court thinks procedures of corporate democracy will help individual shareholders who in their name the corporation is spending money on campaign ads. And we also know that more disclaimer and disclosure of political spending activities is appropriate. Okay, so how can we use Hobby Lobby perhaps to cut back on corporate political speech rights? Okay, so what I come up with is a 3-part test, and it derives to some degree, it's built upon, I've written a paper on this, but I took a look at the HHS, well, I looked at the case, and I told you about the 3 conditions. I looked at the HHS rule proposal, and I looked at 3 different comment letters submitted by different groups of corporate law professors, and I am in one of those groups. And I arrived at these 3 steps. I believe that if there were a new federal or state law, so let's say you just redid BICRA and reenacted it, or let's say you did something else, and I'll tell you about that something else. I think that if the statute carved out, had a prohibition, but carved out corporate entities where these 3 conditions were met, it could work if the court were willing, and this might be an avenue. So one is the coextensivity, that they need to actually look through to identify some human owners there. You've got to see them, and that might involve looking through different layers if they're institutional owners like mutual funds. You've got to see some humans there. Next is consent. So this would be notice and unanimous consent of the human owners, or perhaps notice and super majority consent of all shares entitled to vote to improve engagement in political spending. So it could be every year at the annual meeting as part of the proxy. And finally, disclosure, public disclosure of the spending, which would be, for a public company, easy to do because it'd be in the proxy statement. And I think actually all of these align with what the court would allow under Citizens United, but even further, adding Hobby Lobby, I think it makes sense. So 2 examples would be after Citizens United came down, Lucian Bebchuk and Robert Jackson came up with an idea about supermajority voting. That this would be that normally shareholders don't get a say on many things, and if they do get a say, it's a simple majority vote. They suggested why supermajority voting would be important. Some of this has to do with the agency problems where corporate managers might be spending in their own interests in ways that are aligned with their shareholders. Another idea is in your own state. Jamie Raskin introduced in February Senate Bill 153, and for Maryland corporations, if it would be enacted, they'd be required to disclose within 24 hours their political spending on their website, and that there would be an annual shareholder consent process. What's interesting with their annual shareholder consent process, it's not just generalized amounts, but also one of the consents is about the direction of money and property, like we will give money to this campaign or this issue. What he believes, and at least statements he's made to the press, that this would preclude some institutional investors from voting because of ERISA requirements, which is a separate issue. This could result in a lot of, given that the largest corporations, 70% of them are owned by institutions, obviously many of these votes would fail. Not a lot of, I don't know how many large corporations are incorporated in Maryland, but nevertheless, you get the idea of what legislation might look like. Okay, so what are the problems? There are a lot of problems. The problem is it's difficult to actually map on what happened in Hobby Lobby into a test that would apply to political speech. The second big problem is I'm just embracing this shareholder primacy idea, and we know there are different definitions of corporations, but in particular, why should constitutional rights like this get anchored in what the owners want? We have some of the problems we've already talked about for employees. And finally, what concerns me the most is a sort of, to borrow the medical example, first do no harm. Whoops, is what I'm saying, could it actually be used to expand those rights that were thought to be purely personal in the past? In other words, things that corporations, constitutional rights they would not be thought to have, if we come up with something like this, will we suddenly be able to just look through to owners and actually expand rights further? So this is where I'll end. Thank you for listening.
Thank you very much. And so before we launch into questions, and I'm sure you have many, we have our final panelist, Ms. Louise Melling. Ms. Melling is Deputy Legal Director at the ACLU and the Director of its Center for Liberty, which encompasses the ACLU's work on reproductive freedom, women's rights, lesbian, gay, bisexual, transgender rights, and freedom of religion and belief. In this role, she leads the work of the ACLU to address the intersection of religious freedom and equal treatment, among other issues. And I was excited when she asked to be put last on the panel because I think it's nice to have the three academic perspectives come first and then hear actually what's happening in the trenches and have her perspective on it as well. So we look forward to your remarks.
Thank you so much. I'm delighted to be here. And one of the beauties of going last is you can always say, like, what they said. And, you know, what's really fun about this panel, which is not always true, the panels I get to be put on, is in significant part that's true, with some, you know, noticeable kind of ACLU exceptions, Citizens United. But what I really want to do is bring to you today some perspectives from the advocacy world, and in significant part, sort of how these conversations evolve when we're talking about exemptions from laws to enshrine anti-discrimination principles in particular. For us at the ACLU, we've had a long-standing position that institutional exemptions from laws, particularly anti-discrimination laws, health measures, are unacceptable, probably with the exception of churches, temples, mosques, houses of worship, and there's some caveats there, I think have been suggested before. And that's in large part, that is in significant or whole part really because of the burden on other people and a notion that religious freedom doesn't come with the right to burden other people and to make other people pay the price literally for your religion in that particular way. But what was interesting for me in Hobby Lobby was how many questions arose in the course of Hobby Lobby, sort of requiring us to nuance or how the questions as they arose in Hobby Lobby helped me really see a whole bunch of, I'll just say stereotypes or visions that I think are driving people's positions in ways that I just want to call attention to. And I think Hobby Lobby also raises a very, very significant question about the role of religion and how this conversation right now is proceeding about religion in, I'll say, public life or the public sphere. So just have to start with, you know, that story of someday, I think in February 2012, when the Obama administration sort of came out with an accommodation. It had the contraception rule originally. The contraception rule originally had an exemption. You do not have to comply, in essence, for houses of worship. Storm, crazy storm erupts, right? And there is a storm in particular, sort of most vocal from folks like the U.S. Conference of Catholic Bishops, but also from Notre Dame, other universities, other large religiously affiliated nonprofits. The administration comes up with what is a sort of clever, ingenious accommodation, troublesome, however you want to think about it, which said that those religiously affiliated nonprofits could then certify an objection and their insurer would pick it up. And it was really The Obama administration was trying to take care of everyone in some sense, pay attention to the objection, and try to make sure that women would still get coverage. So out comes the general counsel for the U.S. Conference of Catholic Bishops, who says that there was still a problem with the rule. And the rule said that good Catholic, it still left good Catholic business people who couldn't in good conscience cooperate with the rule. And then he said, if I quit this job and opened a Taco Bell, I'd be covered by the mandate. We laughed. Taco Bell, a religious entity, go figure. 2 years later, the Supreme Court rules, we stopped laughing. But I think it really did call attention to a way of thinking that we hadn't thought of. So I'm going to walk you through a few things. At the ACLU, first the question was, what does it mean? We had no question that we opposed an exemption for Taco Bell, Hobby Lobby, et cetera. But what would it mean for us to say that a corporation couldn't have religious freedom rights? And then a whole series of questions behind that, right? So for us, with Hobby Lobby, right, there's the basic questions. I mean, we aren't in this for the business of for corporations. We're in this either for religious freedom or for the anti-discrimination principles that are at stake on the other side. And how do you think of those two things? Hobby Lobby, nonetheless, was incredibly troubling for the very notion of how we think about, is it demeaning to religion to say that these are religious? What does it mean for corporations and going forward that you get to look back and you look at the owners? How in the world is HHS going to try to figure out who in fact these entities are who are now covered by that decision? Is it that their owners are religious? Is it that their purpose is sort of religious as evidenced and attested to by a whole bunch of the different corporations in these cases? Don't know. But we were clear that that in this context, exemptions weren't okay. But the question was for us sort of, do you come out and take a position saying corporate entities can't make a claim of faith? And I'll just raise for you, just in thinking about this, the one example, and several of you have heard this before, but it's the kosher deli. What about the kosher deli? That you can imagine a law being passed that would regulate the production of meat such that you would not be able to comply with all the rules and have the meat be kosher. Surely that infringes on religious freedom. And would it be important? Is there an entity? Is there a business that would be the entity that would have the standing? You would want them to have standing to come in to say that this is a violation of religious freedom. And here I'm not now talking as the institution, because we did not come out with an institutional position on that. But and the justices raised this question as well in the course of argument. And when I think about this question, I certainly puzzled through a number of different things, and it sort of goes back to Hobby Lobby. But in certain ways, what you really care about is that there's kosher meat available, right? But is that a reason to give the entity? What would that mean then? Is it that the business, because it produces a religious product, would get an exemption? And so then you Google, and it's Hebrew National might be the largest producer, but it's owned by Con Ed or something like that, right? Not who you really think of as coming through and representing a religious freedom claim. But is it product? Is it who the seller is? Who is it? I think ultimately it comes down to a question of the customer, right? So I think that I don't think that the kosher deli should necessarily be an obstacle to saying that corporations don't have religious rights or don't need to have free exercise rights in the sort of context of Hobby Lobby. But one of the things that's really, really different, even when that example comes up, is the context, right? In the context of Hobby Lobby, the question back to what Nelson has said is the effect on the customers, on the employees. Hobby Lobby is getting an exemption, and its employees therefore don't have the benefit. Hobby Lobby is getting an exemption. Its employees therefore are literally paying the price of their employer's religious faith, in that those employees have to pay out of pocket. They don't have a subsidy, unlike the employees at other entities. They're literally paying the price of their employer's religion. In the context, if you're trying to think about the rights of the kosher deli, what you're really trying to do is protect your customers. You're not imposing your religion on customers, even if you imagined those entities having corporate rights. You're trying to protect the customers in a very, very different way. So that's sort of, just as a way of flagging the one sort of sticking point that I think floated around in the advocacy community about whether, and in particular about the religious advocacy community, about whether to come right out in the case and file saying, no matter what, we are people who care about religion, and you should not say that corporations could ever be asserting claims under RFRA, could not be persons for purposes of the RFRA context, as distinct from that they should lose in the RFRA context. But one thing that was just interesting, and Nelson's examples sort of suggested this, but people were outraged in a very fundamental way. People saw a major disjuncture in the notion that Hobby Lobby, with over 14,000 employees selling sequins and yarn in cities across the country, could come in and say that they were religious. And it's true, it's the first time I think the Supreme Court, has expressly said that it was going to grant the personhood for this purposes of religious freedom to a for-profit business in this sense. But well before this decision, for-profit entities have been asserting a right of religious freedom and claiming rights to exemptions from otherwise generally applicable laws. That's true in terms of the florist, the flower shops. It's true in terms of the bakery. It's true in terms of the pharmacies. Earlier, I won't even remember which decade necessarily, but when there were waves of laws passed to say that pharmacies had to fill prescriptions, for example, for birth control and emergency contraception, there were pharmacies that filed suit. There's still one case active, saying that ran against their religious rights. But that didn't produce the tittering, right? That didn't produce the laughter that the Taco Bell example did for some reason, right? The conversation was as if this was the very first time in the context of Hobby Lobby. And I think this goes back in part to some things that Jennifer was saying, which is, in that context, I think people actually saw in their head the owner. In some way, they didn't see the business. It's a business, and the owner is not functioning in there as an individual, in that the owner was saying the entire business would turn you away, in a way that I think is very different from if it was an individual pharmacist, maybe, saying, I won't serve, but I have to go take care of something else, but Jennifer, my friend here, will help you, in a way that doesn't then impose the burden on someone else. And what's interesting about Hobby Lobby is not only in terms of piercing the corporate veil, but it's as if what the court did was take that owner picture that we had for the pharmacy and transport it over here, and it's not as if that is what it did, transport that image right onto Hobby Lobby in a way where, I'll say from our standpoint at the ACLU, we've been working really hard for years now to get people to understand that the pharmacy isn't the owner, the pharmacy is more like the chain store, in the sense it is a business, right? And how you see that literally has, I think, lots of implications for how you think about the policy, at least in those spheres in the state legislatures where we're working in sort of terrain that's not necessarily cabined by the Constitution, and therefore it's a policy debate about who will you let out, who will you exempt, which choices are you making. And when the face of the owner is the dominant, then I think the conversation is different than when it's the business. So I think one of the questions is whether Hobby Lobby and people's notion of sort of the indignity of that can help carry over, perhaps to Citizens United, but also perhaps over to these other debates as we see now happening in Indiana, in RFRA, and in other contexts. So that's one way. The other way I just want to flag, even though this is about the business side, is that's the debate, a vision about individuals and business and exemptions that's going on in the for-profit arena. But I think there's a parallel almost in the nonprofit arena. And in saying that, I think we just want to think about how real these distinctions are. I certainly don't mean it in the corporate law sense, but I mean it in the cultural sense. I was at an editorial board meeting with a paper on the morning that accommodation came out. I was meeting with the editorial board to try to convince them that they should come out editorializing against the religiously affiliated institutions and their claims for an exemption. I've met these people before. One of them says to me, "Oh, Louise, come on. you're not really going to say that the Catholic hospital has to provide coverage, are you? You don't really think, I mean, I worked in a soup kitchen, you're not really going to say that they have to provide coverage. And it was, I say this, I'm not trying to mock, this is a very good person, this is a smart person, a caring person. But clearly what he had in mind, first of all, was the soup kitchen, something very, very personal. And I don't know exactly what he had in mind with the hospital. I was kind of trying to give him credit that he had in mind sort of what my mother might have known when there were like different religiosity hospitals in the city and you all went to your own. But I said, 10 of the 25 biggest healthcare entities in the country are Catholic. Nearly 1 in 10 hospitals in the country are Catholic. It's true that in many places there is no other hospital. Like this is no longer an instance of serving your own. These nonprofit entities are now in effect, not in the technical sense of corporate law, but businesses. They are now big businesses serving the public and providing accommodations, thinking of them as only sort of small charities and therefore exempt. Distorts what's really happening. But again, it's that very personal, individual vision that I think is going forward. I just want to close with talking about how I think that this is all part of a broader conversation of religion in public life. What we see in many instances, right now, for example, there's a big debate about whether Catholic charities and other entities can get grants to serve refugees, unaccompanied minor refugees. The basic rule says you're supposed to provide, to get this grant, you're supposed to provide certain care. That care includes referrals and other information about contraception, emergency contraception, and abortion. Different religious entities say we should be able to get that grant, but not provide those services. That's just one example of many ways in which Hobby Lobby says we should be able to function, have all the benefits of being a corporation, but we should be able to get out of this rule. Other hospitals say we should be allowed to get government money by serving Medicare and Medicaid patients, but maybe we don't have to provide referrals and all sorts of information about different care that we find objectionable. When I've been in private meetings with some people running these institutions, people say this isn't just about us providing food. This is actually our mission. This is a calling. It's a religious act to provide the health care. It's a religious act to provide the services to refugees. Therefore, to shut us, to treat that just as separate from our religiosity in the way that you, Louise, are advocating as policy, is definitely infringing on our religion. I think that's one of the big questions, which is evidenced by Hobby Lobby, which is which decisions are we going to make about who gets burdened in some sense, about whether you're going to burden the religiosity of people working in those institutions or running those institutions, or whether you're going to burden the people who are served by those institutions or employed by those institutions. And there, I come back, we share the view that if you're playing in the public sphere, you should abide by the public rules, particularly where that's going to cause discrimination and harm to third parties. Thank you.
Okay, terrific. So we have about 20 minutes for questions, and I just want to make a general observation and kick us off, but I welcome questions among the panelists as well as questions from the audience. And it's interesting, I think, listening to our 4 panelists, I could identify points where we probably have agreement, and points where I think we would have vehement disagreement. And I think it's because this is a very nuanced, Nelson, as you said, issue. It's not just big for-profit corporations are bad and shouldn't get exemptions, and we need to focus solely on the burden. There are levels of analysis within each of those extremes that I think people need to appreciate. And I will say, Louise, to your point on focusing on the identity of the business as being the individual, I think that's one perception that makes this issue particularly challenging. But also for me, when I think of the various types of ways people can do business, right? And so it's proliferating right now. You can be a B Corp. You can actually have as your mission something to do good by your societal views. And so I think it's not only thinking about the economic burden on the employee, but also when you're talking about these closely held corporations, the limitations and restraints on the investors who may be wanting to invest their money in a corporation with a certain purpose. And so I think there are different ways to look at corporations, how they're formed, and what, Louise, as you were saying, their mission is. And I don't have a good answer. I don't think there is any one answer. And I find very valid and compelling points in everything each one of you said. And so my question to you, after that long-winded explanation of saying that I think this is, you know, certainly an issue that we're not going to wrap up in 20 minutes, but, you know, having heard the positions you stake out, right, and the thesis that each of you offer, you know, do you see merit, for lack of a better word, for example, in Jennifer's attempt to find a less extreme way to draw the lines? Because I really see, and I should say Professor Taub, trying to find a way to work with the nuances in these issues and accommodate everyone's interest to the best we can, even though it's going to be an imperfect way. And I'll let anyone who wants to tackle that try to, but that's where, I mean, does it have to be black and white, or can we find a nuanced way?
I'm willing to go, which at least in the, if we think about the context, there's a raging debate going on right now in the context of every single provision that's being proposed to advance the rights, for example, of LGBT people. And I view measures, for sure, like the contraception measure, as a move to end one basic form of discrimination against women. If you look at what's happening now, and then you look back even at the time of the Civil Rights Act, what you're seeing is a similar pattern, which is at those moments of giant cultural change, and I actually view it almost as like tectonic plate shifts. Those are hard changes for people in very profound ways, and at those moments of change, you see these calls for exemptions. And I'm actually quite sympathetic to how hard it is to run contrary to your faith, and to be told that you have to go contrary to your faith, and to have penalties attached to that, and that we all grow up with certain sets of custom or assumptions as well as beliefs, and the culture may just change around us in ways that are always challenging. As I say to my office staff, like, you have a hard time if we change the office operating system in the computer. Imagine when the entire culture changes around you in really profound ways. But in those contexts, at the end of the day, I think, look, somebody's paying the price. Either the person who's told you have to violate your religion, or the person who's turned away because of who they are. And I guess at the moments that you have your arc of justice going toward equality, I don't see how you actually get there if you say that you're going to leave in place holes. You're going to say that if somebody's traveling with her partner, a woman is traveling with her partner around, and she can get turned away at a hotel because of who she is, why would you feel that society was actually treating you equal? How would you then feel when you go to the next hotel? You don't know where you're going to be still rejected because of who you are, even though there's an anti-discrimination law in place. So I have sympathy. I believe it's hard, but I don't actually see a way in the law to have nuance if you want equality to be whole.
Can I just have a quick response? I agree with Professors Corbin and Tebbe, and I have to say, I guess I'm arguing against myself, but one of the things I held for now, you might recall when I said, you know, the court was convinced that Hobby Lobby, Martel, and Conestoga were actually operating their corporations according to the religious beliefs of their owners. What I found interesting is I think a few days after Hobby Lobby came down, it came out in the press that Hobby Lobby's 401k plan, I believe, had been invested either directly in stock or in a mutual fund that had a sizable position in a company whose main product was birth control. So at any rate, I mean, where I come out in terms of what I think the better arguments are in the areas outside of where I practice is where you are. But as a corporate law scholar and concerned about where Citizens United left us, I'm very pragmatic, and I see that this Hobby Lobby decision was 5-4, and so was Citizens United, and I'm just simply trying to create a path, that maybe a future court would take the time to follow. So it's pragmatic and optimistic. It's not where my philosophy about this is.
All right, yeah, I don't see it as complicated. So you have a choice between the billionaire owner of Hobby Lobby who made the decision to incorporate his company, and the reason they made that decision is most likely to gain the benefit of limited liability. And the main point of limited liability to say, listen, you and your company are distinct entities, so the financial obligations of your company will not accrue to you. And that is the point of limited liability, to become separate and distinct. So to decide, as you say, there are many different ways they could have organized their company, but they decided to organize it as a limited liability because they did not want to be one and the same as the corporation in order to protect their finances. And if you're not going to be one and the same for financial reasons, I don't see why you suddenly get to be one and the same for your religious rights. I'm not done. Also, right? Also, I do think that there are religious interests on both sides, right? On the one hand, you have the religious liberties of the owners, who are, by the way, right, the owners who have put their company not only as a limited liability company, but have put it in trust for additional economic reasons, right? These are billionaire people who don't have to take contraception, whereas for women, taking or not taking contraception can have religious ramifications. I mean, there are some religions that say, part of your religion is making sure that if you give birth to a child, you have the ability to bring it up as God intended, right? So there are religious reasons for taking contraception. And so you have the billionaires on the one hand and the employees on the other hand. And it's like the freedom of association claim when we're talking about desegregation, where people completely overlook the incredible power imbalance between these two groups of people. And I really think that when we start saying we are going to make exceptions for the benefit of the elite so that they can practice their religious liberty at the cost of people who desperately need protection from their employees who have a tendency to exploit them, right? It's not as hard a decision for me.
But can I just interrupt one sec? And I respect that. And so it may be, though, that Hobby Lobby is a bad example, right? Because you keep pitting the billionaires against, it's like the Wall Street, Main Street dialogue we had throughout the crisis. Most companies in the United States are above the 50-employee limit and well below the Hobby Lobby billionaires. And, I just want, and you will probably never agree with, thinking about the various permeations of what it means to be a limited liability entities. And you can be an LLC, which is very personal to its owners, as opposed to a corporation with limited liability. So again, the only issue I had, because I understand your thesis, and I think, like Professor Taub, appreciate it for where you are, but I think there are permeations of doing business in this country that aren't captured by that extreme.
Right, and I just want to point out that the contraception mandate did not apply to those small businesses. You had to have at least 50 employers before you triggered the requirements. And so it may be that the questions are different for smaller companies, but that's not the question raised by Hobby Lobby and government protections.
I know you guys want to ask questions, so I'll be brief. But I haven't taken a position on whether the court was right on the corporate religious freedom question, because I think it's pretty hard. So Justice Alito has this kind of hypothetical, which was explicit oral argument, but implicit in the opinion, sort of below the surface. But he essentially asks, imagine you have an individual and she runs a business as a sole proprietor. And it could even be a pretty big business. Let's say it has 5,000 employees or something. there's no question that she could bring a religious freedom claim, right, if that business was faced with a regulation that she had religious objections to. The moment she incorporates, right, that person loses the ability to bring a religious freedom claim. That feels formalistic, right? So now we need a reason why the law should draw the line there. Why should it be, and nothing else changes. She remains the sole shareholder, she's in charge, she's in control of the company. It's just she's adopted the corporate form. Is it really the case that the law can make sense of depriving her of religious freedom at that moment, and what would make sense of it? I've struggled with it. I'm not sure what the answer is. One possibility, because there are different theories about what corporations are for, and which theory you adopt may have a difference on your answer to the question. One possibility might be, though, that if you have a theory that the corporation is for, like the reason we have limited liability is so that corporations can amass capital, right? It's for capital accumulation. Then you might worry that that reason, right? This is not formalistic. It goes to the substance of what a corporation is. That reason suggests that there's going to be an impact when we exempt those corporations on third parties that's going to be disproportionately large. Not in every case, maybe, right? But in the vast majority of cases, so you could adopt a no religious freedom rights for corporations rule as a prophylactic measure, right? As an administrable prophylactic measure. That wouldn't make sense in every single application, but would make sense enough of the time because of the purpose of the corporation, which is to amass capital, that we should adopt that kind of prohibition. That's as close as I've come to an answer to the question, and it mostly supports, I think, what Carolyn was saying, but for a different kind of reason. I guess one question I would have for Carolyn is, if it's the case that the entity itself can't bring a claim, but the individuals who either own or control the entity can still bring claims, what will be the practical difference? There were some lower courts in the Hobby Lobby cases, specifically the DC Circuit in the Ghilardi case, that took that position. So they said, under RFRA, a corporation cannot bring a religious freedom claim, but the individuals who own and control the corporation can bring the claim, and they won. Right? If that's going to be the outcome, then I wonder what the fight is really about as a practical matter. So that would be a question for Carolyn. For Jennifer, I'm interested to know, whether we don't have mechanisms for making determinations, even determinations of value or morality, even for large corporations. Right? So we understand how to make a decision about, for example, whether and then how the company should spend its sort of charity money, right? Or we might even have a company that gives away 10% of its profits or all of its profits, even a for-profit company, to charity, or let's say 1% of its profits, just to make it reasonable. That's still millions of dollars for a company like Ben & Jerry's. We have mechanisms for for resolving disputes about that. I don't see anything in principle in the Hobby Lobby decision that prevents extending religious freedom protections to a company like that, as long as we have a mechanism for resolving disputes about where to and how to spend that money. And as for shareholders, why they would sign on to a company that has a religious identification, I can think of lots of reasons. Like the company's doing really well and they want to share in the profits, and they're willing to stomach the fact that the company has a statement about religious commitments, even in its charter, which Hobby Lobby did. So I wonder, I guess I'm a lot less optimistic than you are about Hobby Lobby itself and what its implications might be. So I'm just curious about that.
So two parts. There's the Hobby Lobby itself, right, the test that HHS might come up with, and then there's the corporate political spending part, right? Answering the first part, I think one of the things you asked is really interesting about how, would it be part of HHS's test, or even the one I said was a condition, that the corporation actually be run according to certain religious beliefs, and how would you distinguish? And two of the comment letters from professors, one from a group from Berkeley and one organized out of Columbia, address this. And the Berkeley letter, I think Caroline would like a lot, because it basically says, if you are going to choose this exemption, you have agreed to be veil-pierced, and that's it. But both of the letters suggest that there's got to be some kind of declaration or certification that you're running a company that way. In terms of though the other question about whether people would, I'm less focused on the religious freedom piece and more interested in corporate political spending. And I think what Jamie Raskin has figured out is that if you craft legislation in a certain way, it might actually preclude institutional investors from voting. And I have to look into ERISA. I know a little bit about ERISA, not enough to see where he's headed with this. And if that is the case, if it's specific enough that they have to approve particular political expenditures, it might either be ERISA or it actually might be the it might be the pay-to-play rules. So that could be really pretty interesting. So, but good question. I think people would be happy to be with, Chick-fil-A or whatever company it is if it's profitable. But the question is, what should the tests be, and where will HHS end up on this?
Terrific. Do we have questions in the audience? Yeah, go ahead.
My question is going to reveal a little bit of non-believer bias, I think, because some of what Louise said resonated with me, that oftentimes I think that cultural beliefs inform religious interpretation rather than the other way around. So I'm wondering, once religious freedom promises more than, free thought and free belief, but actually sort of positive rights to practice it at all times, or in many times and in many ways, it seems to me inevitable that courts will wind up distinguishing on the basis of the substance of the belief itself and finding some legitimate or sort of culturally accepted or socially accepted enough, whereas, maybe my church of 420 that wants to start a marijuana sale business or something can't be taken seriously. So I'm sure that this problem comes up or has come up well before Hobby Lobby. But how does the sort of the establishment clause wind up interplaying with things like Hobby Lobby and these exemptions?
I'm not sure exactly how to respond, but let me just observe historically that, RFRA, when it was enacted in 1993, I think was mostly viewed as a statute about religious minorities, right? So the major religious groups in America at that time had on their agenda, claiming a place in public life, right? And so this was the age of the moral majority and so forth. Like, they wanted to enact their policies into law, right? And RFRA was about, strange small groups that, couldn't enact their preferences into law and needed exemptions from general laws. And when it was about that, these strange small groups didn't do so well for some of the reasons that you suggested. So I represented a Rastafarian, actually, in a marijuana claim when I worked for the ACLU, and argued it in the Ninth Circuit. And there was a RFRA challenge because this guy was from Guam, so the law that he was violating was a federal law that applied in the territories. And so we had a federal RFRA claim that he ought to be able to use his marijuana, or actually he just wanted to import it from Hawaii to Guam, right? That he was charged with importing marijuana from Hawaii into Guam under Guam law. So the federal RFRA definitely applied, and he lost. Why? Because the Ninth Circuit, in an opinion by Judge O'Scanlan, you can look this up, said, we just don't believe him that importation is part of his religion. That is not allowed, right? I mean, one of the holdings of Hobby Lobby is we take what person's religion is at face value, right? It's unconstitutional for a court to question whether someone's sincerely held belief is, really a part of their religion, as long as it's sincere. And there wasn't a question about that in the case.
And as long as it's outside the prison context. Just kidding.
Well, there is Holy House, but yeah. Now, though, we see these kinds of RFRA claims being brought by major religions, right? So by the Roman Catholic Church or evangelicals in the case of Hobby Lobby itself, and they're taken much more seriously. So RFRA has a different kind of valence today for the reasons that you say, than it did then. And just parenthetically, I think that non-believers ought to be able to bring RFRA claims too, as a matter of principle. But whether that's going to be possible as a matter of reality or sort of adjudication is hard to say. There is a case on the books from the Seventh Circuit in the prison context under Arlupa, which is a cognative RFRA that applies only in the prison context, where the Seventh Circuit said, for the purposes of Arlupa, non-belief is a religion and it gets covered. It has protection under Arlupa, so that's a glimmer of hope.
Terrific. Well, I actually think we're out of time, but I want to thank all the panelists. I think it was a very interesting dialogue, and one I have a feeling is going to continue for some time. So thank you very much.